Today we're going to talk about which trust do you trust, right? Irrevocable or revocable. It's going to be a great conversation. So why don't we get it going? So first to the firm, we started well. The founder, Tim Borchers, was just reminding us this morning we're going on 30 years that we've been in existence. So originally started in Medfield, then had moved to Medway for many years. And then just recently, at the beginning of 2023, so a little over a year ago, we moved back to Medfield in our current location here, mostly because we're growing. And when I joined up with Tim as a partner in 2015, there were 4 of us, and now we're approaching 20. So good problem to have, right? But yeah, today we're in our new learning center. We're excited to be here. And our firm specializes in trust support, trust planning, trust support, trust administration, and trustee services. And we really consider that our focus. There are a few other areas that we touch on, but that's what we're good at. And as you'll see today, and you see it in the name of the firm, right? It's Borchers Casano Trust Law. That's what we enjoy doing. And we are practicing primarily in Massachusetts, but we do have another location in Concord, New Hampshire. That's a newer location. And our attorneys are admitted in several states. I'm admitted in New Hampshire as well, and New York. We have Florida, we have North Carolina, we have Rhode Island. So we've got a lot of states covered. But without further ado, let's just jump into what we're going to cover today. So I want to go through a few different things. I want to talk about the history, a brief history of trust. I think it's kind of interesting. I want to talk about what is a trust. Let's get a basic definition in place. And then let's go through the difference between revocable and irrevocable trusts. We'll talk about the tax treatment of trusts, and then possibly declare a winner to be determined. So trusts, we see trusts kind of all over the place in history, and you could look all the way back in Scripture and see references there. For example, this scripture from Galatians says the heir is subject to guardians and trustees until the time set by the parent. I mean, we're still doing that today. I have that conversation, I feel like, multiple times a week. Let's set a time at which the children can get access to funds. So we see it there. We see trusts in ancient Rome, where only Roman citizens were allowed to own property. And when faced with deployment, soldiers would transfer ownership of property to a trusted friend to make sure that families were taken care of. And one of the stories goes that there was a Roman citizen who did such a thing, transferred property to a friend for the benefit of his wife. And the friend, lo and behold, didn't use the assets for the wife and decided to just run away, use them for himself. And apparently this enraged the emperor at the time, and so it ended up going to court, and that's when the court officially recognized trusts, or so the story goes. And then we also see trusts, in America. George Washington served as a court-appointed trustee for his stepchildren. So it's not a new phenomenon. Trusts had been around for a very long time, and they certainly have evolved, and we're going to see many different types. So let's just start with a basic definition. All right, what is a trust? A trust is when one person transfers property to another person with instructions that the property be used for the benefit of someone else. All right, that seems fairly easy to grasp. Let's break it down a little bit further. 5 ingredients. All right, we have a grantor. That's the when one person part. A grantor, sometimes called a trust maker or trustor, but a grantor, that's the person making the trust. Transfers property, so you have to have property that you put into it. A trustee, that's transfers property to another person, that's called a trustee, with instructions. Trustee has to be told what to do with the property, and it's meant to benefit someone else. So that's our beneficiary. So let's look at an example of the Casano girls. So these are my girls. On the left is Anna, she's 15. In the background is Teresa, she's 12. And in the foreground is Jenna, she's 9. And this picture was actually just from this past weekend. You'll see Teresa is holding a black lab. So we have an 8-week-old pup that we were, I don't know, were we crazy enough to say, let's do it? You know, we don't have enough going on. Let's add a puppy to the mix. So that is, that's Rocky back there. So we have a routine in the Casano household. It's Friday night movie night. And on Friday nights, most Friday nights, we pop popcorn. And I don't do the microwave popcorn, I do stovetop. Grab the kernels, melt the butter in the microwave. And Jenna still at an age where, you know, she wants to help out. She helps to melt the butter, get the salt out, and help fill up the popcorn containers. So we'll work on that. I'll pop the corn. When it's ready, fill the containers, hand them to Jenna. Okay, Jenna, this one's for Anna. This one's for Teresa. Go ahead, take them out in the other room to your sisters. So right there, that's a trust. All right, we have all the elements. Let's back up on the slide and go to our ingredients again. Right, so we need a grantor. In that example, who was the grantor? Me, that's right. I was the one person. I transferred property. What was the property? It was the popcorn. I transferred it to another person. Who did I transfer it to? My daughter, Jenna. She's the trustee. I gave her instructions. Take the popcorn for your old and bring it out to your older sisters. And who are the beneficiaries? Her sisters. So that's a trust, right? Except we're not always going to use popcorn for that example. So let's just keep that in mind as we're going through our talk today. That trusts don't have to be scary. You know, you have those elements in there, you have a trust. So the most commonly used trust that you hear about is a revocable trust. Most of the time, or many times, you'll hear it referred to as a living trust. What that really means, a living trust is technically any trust that's created during your lifetime versus a trust that gets set up at death through your will. Most trusts are not set up through your will. Most of them, the vast majority, are set up during life, and they could be revocable or irrevocable. So when someone says, I have a living trust, it could mean they have an irrevocable. I think most of the time they mean revocable. So just by the way it sounds, revocable is the type of trust that you can revoke. You can take back what you put into it. It can be changed at any time. You can change one tiny part of it. You can say, I don't like the trustee I chose. I want to do a new trustee. I don't like my child anymore. I'm taking them out, putting a new one in. You can change just one part of it, or you can change the whole thing. You can say, I don't want this trust anymore. I want a brand new one. And for any reason, you retain complete control over the assets or the property in the trust. You are the grantor, the trustee, and the beneficiary. So if we go back to our example of the popcorn, if technically in that example, let's think that through. Was that a revocable trust? Well, I created it. I gave the popcorn, the property, to my daughter, Jenna, and I gave her instructions that she's supposed to use it for the benefit of someone else. Well, in a revocable trust, I'm supposed to be the creator, the grantor, and the trustee and the beneficiary. So it would have meant I would have filled the popcorn container and just given it to myself and then just started eating it. That would be a revocable trust, because then I could do whatever I want with it. But because I decided to say, no, this is for the benefit of someone else, and I gave it to someone else, it's not revocable. I didn't have the right to ask Jenna, hey, give me the popcorn back. So revocable trusts are quite common for that reason, because you don't give up control. And I think that's hard for a lot of people to grapple with, is that idea of control. We'll talk more about the tax part later on. So why would you use a revocable trust? Now that you know what it is, what are the purposes of it? I'd say there's probably 3 primary reasons why someone would use a revocable trust. One would be probate avoidance. So we have to think about at the time of death, how are we going to pass our assets on to our loved ones? And probate is a court-involved process. It's not an easy process to go through. It's easier than it used to be, but still delays. You're dealing with a court, so it's a public process. Anybody can go in and see your will and who your beneficiaries are. There, of course, there are court costs and fees that have to get paid, and there are just delays. You're dealing with courts. Typically, it would take around 45 days just for a probate proceeding to be opened and ready to go. And then once it's opened, you can't close it for an entire year after death. So we try to avoid that when we can. But backing up, I guess one question is what would even trigger it? How would you end up in probate? Well, I think a simple example would be if you had a bank account that was just titled in your name alone and you pass away, there's no joint owner on the account, there's no beneficiary, it was just your name. And now say your child wants to get access to it, they can't just walk into the bank and say, oh, hi, I'm the child of so-and-so, give me access. The bank's going to say, sorry, you need to go down to court and you need to become the executor of your father's estate. And once you have your papers from the court, then come back to us and then we'll give you access to the money. So that's what would trigger it, is anytime you have an asset, could be a real estate, could be a bank account, could be an investment account, anything in your name with no designated beneficiary or other owner, that could be a potential probate problem. Trusts would be useful in that case if that bank account were owned by a revocable trust, and in the revocable trust, you named a trustee. So you'd be the trustee, right, in a revocable trust because you are the grantor, the trustee, the beneficiary. But when you die, you need a backup. So you pick your child, let's say, as that trustee. And the child can go into the bank and say, hey, look, in this trust document, I'm named as the backup trustee. You have to give me access to the money. And the bank says, you're right. There you go. You get access. We'll put you on the account. There's no need to go to court. So the trust just completely avoided that entire probate process. Another benefit with trusts, and a reason to use a revocable one, could be to save estate taxes. So there's potentially an estate tax that gets assessed against your estate at the time you die, sometimes referred to as a death tax. There is a federal estate tax, and there's also an estate tax in Massachusetts. The federal tax limit is $13.61 million. So if you have more than that amount at the time you die, then there's a tax. For Massachusetts, the limit is $2 million. If you have more than $2 million worth of accounts, assets, then you're subject to a tax. A revocable trust can help married couples to put their exemptions together and combine them so that they can maximize the amount they can pass on. So let's use Massachusetts as the example. You have a husband and a wife, they have $2 million each as an exemption. With a revocable trust, they can put them together so that they can pass $4 million tax-free to their children. Without a revocable trust, they could not do that. They could only pass $2 million. So I'm not going to go into any more detail on it. The state tax discussion could be a whole nother presentation, but I think just understand that there's a benefit there when you use a revocable trust. And then finally, revocable trusts are often used to provide inheritance protection for beneficiaries. And we refer to this as protection against the killer Ds. So inheritance trusts will help to protect against the killer Ds. The killer Ds are divorce, disputes, debts, disability, death taxes, and destructive spending habits. So the idea there is if you have $500,000 that you're leaving to 2 children, and one of your children receives their $500,000 inheritance from you directly, and then a year later, they go through a divorce. Because that money would be in their personal control, it would be exposed in a divorce proceeding and could potentially be be subject to division in a marital separation agreement. So the idea behind inheritance protection is, what if we could put that $500,000 in an inheritance trust for that child, so that if the child was faced with a divorce in this example, then they could legitimately argue, hey, that money I inherited should not be considered as part of this divorce proceeding because it's in a separate trust that I didn't create. My parents created it for me, and it's money they left me, and I don't have the right to take it out or to get at it. And so therefore I can't divide it with a spouse. So that's one example of how an inheritance trust can benefit. And you often see them built into your revocable trust. So you do the revocable trust today, you put your house in, you put your bank accounts in, all your investments, and within your document, you say, I have my family, I want to provide for them, I do want to divide everything up evenly, but when it gets divided, I want it to be a separate trust for each beneficiary so that they are protected if they go through a divorce or a lawsuit, or they have creditors trying to get at their money, or they go on mass health because they're in a nursing home. So you can protect that inheritance for them. The inheritance trusts are, they're technically irrevocable trusts because the beneficiary didn't set them up. You're the one that's setting that up for them. So the beneficiary doesn't have the ability to revoke it, but they really wouldn't necessarily need to, and wouldn't necessarily want to, because that would interrupt the protection they would get. It's best to have an independent trustee manage that inheritance trust. So it could be like me, with the popcorn example. I set up an arrangement with my daughter Jenna, and it says, look, when I'm going to put some popcorn in this trust now, but look, when I pass away, I've got a whole vat of popcorn waiting and ready that I'm going to add to that trust. And you, Jenna, you're in charge to divide that up among your sisters. And when you do that, you got to put someone else in charge of their particular share of the popcorn, because I'm a little worried about your older sister, Anna. She's got some friends that love popcorn, and I'm just afraid that they might go after her popcorn when they realize she's inherited it from me. So Jenna, I want you to choose someone else to manage that popcorn for her. So that's kind of what the concept of the inheritance trust. One nice thing about these that we're doing now that wasn't done in years past is it is a separate trust. A trust is a separate entity, and we're going to talk about that more in a minute. But the way we set these up, the beneficiary, the child, will not have to file a separate income tax return for this inheritance trust. They'll get their inheritance in a trust, but they can still just put the taxes on their personal return, and they wouldn't have to do a separate tax filing. So that's a nice feature that would make the administration a little easier. So irrevocable trusts, I think we've kind of touched on this already. You can imagine they're the type of trust that you can't change. So you're putting an asset in and you can't take it back out. It can't be changed by you, but it could be changed in other ways. And there's 3 examples here of a trust protector, powers of appointment, and decanting. Very briefly, let me go through those. So a trust protector is someone you can name in an irrevocable trust. You can give them power to make some changes for you. So since you're not allowed to change it, it doesn't necessarily mean that you can't give someone else the power to change it for you. So that's what a protector would do. They have limited powers, but they can make certain changes. Powers of appointment are powers where you can change who the ultimate beneficiaries are. So let's go back to the popcorn again. If I put the popcorn in the trust and give it to Jenna, she's the trustee, and it's irrevocable, I don't have the right to take it back. The beneficiaries are her sisters, Anna and Teresa. But what if I change my mind? What if I say, you know what? Anna's had enough popcorn. I think Teresa should get it all. if I have a power of appointment in the trust, then I can exercise that power and I can instead decide to appoint the popcorn to Teresa instead of having it go equally between the two. So it's some strings that I've retained if I change my mind in the future. So that's why we say, you give up control, but not access. Well, access, let me talk about that in a minute, because there is a very specific kind of trust that deals with that. But going back to the ways to change, there's also this concept of decanting, and it's taken from the concept of wine decanting. So we're actually going to have a talk by one of our associate attorneys, Deb Hedges, in a few weeks, and I'll mention it at the end. But it's going to be called Legacy and Libations. We're going to have wine available for that, but I don't think she's decanting the wine. But maybe she could talk about decanting a trust. The concept there is when you decant wine, is you usually move it from an old container to a new one, and when you do that, you leave behind the unwanted sediment. So it's the same thing with a trust. You can move the assets from one irrevocable trust to another one and leave behind all the unwanted provisions of the old irrevocable trust. So it's another way of changing your mind. So why would you use an irrevocable trust? Well, you'd use it for all the reasons that you'd use a revocable. Like, irrevocable trusts will avoid probate. They'll save some estate taxes, and they can provide the inheritance protection. So everything a revocable does, plus these items here listed. So for example, if you have more than 13.61 million, or if you have more than, say, 4 million in Massachusetts, for Massachusetts purposes, you could put that excess in an irrevocable trust, and it will not be subject to estate tax when you die. So you could put that in now with a gift, and if that money, say you put 13.61 million in, and then at the time you died, it grew to 20 million. That entire $20 million would all be estate tax free to your family. So they call that a freeze technique. You're using a gift amount now and kind of freezing the value at today's value. And then, hey, if it grows, great. It's all going to be tax-free growth. You can use irrevocable trusts to save state income taxes if the trust is administered in a state that has no income tax. So, for example, New Hampshire. New Hampshire has no state income tax. If you create an irrevocable trust and you have it administered in New Hampshire, then all the income that trust generates could potentially be income tax free for state purposes. You still have to pay a federal income tax. You can't avoid that. But if you go to a state that doesn't have a state income tax and your trust is sitused there, you might save state income tax. Not right in every situation, not right for everyone, but there could be benefits there. This next one in bold, long-term care protection, that's probably the most common type of irrevocable trust that you'd hear about. I'm sure you've heard about it all over the place. And it's sometimes referred to as a Medicaid asset protection trust or an income-only trust. We refer to it as a legacy asset savings trust, last trust for short. And the idea there is whatever you transfer into such a trust, because it's irrevocable and you don't have the right to take the assets back, then after 5 years, there's this whole 5-year look back period out there. After 5 years, the assets in that trust are theoretically now protected from having to be spent on nursing home care. And the goal of such planning would be to try to qualify for Mass Health benefits, or Medicaid. So Mass Health is the Medicaid program in Massachusetts. To qualify for Mass Health to pay the nursing home bill rather than having to use your personal assets to do so. That type of a trust takes thought, but it's quite common and has to be done, though, well enough in advance. We typically say age 70 to 75 is a good time to be thinking about that kind of a trust. Again, because it's irrevocable, if you do it too early, you are giving up control, and that may just be unnecessary and complicate life. But if you do it too late, you have this 5-year window to get past. So we see that age range to be a good appropriate time to be in thinking about it. Irrevocable trusts can be used for liability protection. For example, with rental property, if you're worried about liability and properties owned by an irrevocable trust, it can insulate you from protection. And then it can also provide some divorce and creditor protection. So we talked a little bit about that divorce protection earlier. There was a case in Massachusetts last year that dealt with divorce protection over that kind of a trust. So they are always being reviewed, scrutinized, but if they're set up the right way, they can provide some protection for that issue as well. So that brings us to our acronym avalanche. Us lawyers love our acronyms. So let's just look at, these are just some of the common types of irrevocable trusts out there. We have a CRUT or a CRAT. Those are charitable trusts. So it'd be charitable remainder unitrust or charitable remainder annuity trust. They're irrevocable. You can put assets in and you could have the right to get some income from the trust for a little while. And then at the end of that term, whatever's left in the trust will go to charities of your choice. SLAT, a SLAT is a spousal lifetime access trust. I alluded to this earlier. It's an irrevocable trust where you could potentially retain some access, and you would do that through your spouse. So typically it's each spouse creates an irrevocable trust for the benefit of one another. Let's go back to the popcorn again. Boy, everyone's going to want popcorn after this talk tonight. You must be salivating. So if I build up the popcorn containers, I give them to Jenna as the trustee, but I say, Jenna, take this popcorn out to mommy, my wife. So my wife becomes the beneficiary. Well, and I do that because I'm not quite sure that Anna or Teresa would give me any of their popcorn if I wanted it, if I asked them. So, but I'm pretty sure my wife would. So she holds the popcorn for the benefit of my wife. So now I can get access to the popcorn through my wife, and my wife sets up the same kind of trust for my benefit. So she can get access to the popcorn through me. So we have this cross benefit. So even though they're irrevocable trusts, we can still access the assets. An IDGT, IDGT. An IDGT is a defective trust. Why in the world would we want a trust that's defective? I have no clue other than the fact that that type of trust avoids estate tax, which is nice. But at the same time that it avoids estate tax, you still are responsible to pay income taxes on it. So for some reason, the creators of such a trust decided to label that as defective, which I guess in a way you might say, hey, why do I have to pay the income tax on it? It's out of my estate. I'm not going to pay estate tax, but there are benefits to doing that. An ILIT, this is another common irrevocable trust. So irrevocable life insurance trust. That's a trust designed to hold life insurance policies only. And when you put a life insurance policy in that kind of a trust, when it pays out at death, all the death benefit proceeds would be estate tax free. There'd be no estate tax at all. So that's a nice vehicle, especially if you have large life insurance policies. So I think you kind of get the idea here. There's GRATs, there's ADAPT, there's LAST trust. I mentioned the LAST trust is the Medicaid trust, BDIT, QTIP, QPERT, RPTs, and more. So there's the acronym avalanche here. Did you hear about the lawyer who was buried under the acronym avalanche? As the story goes, his attempts to make sense of all the trust acronyms buried him. They say he was last seen exclaiming, "Ah, crap," and slat himself silly while getting idgety with sleepy eyelids. When asked if he was a recent law school grat or a dap fool, he replied for the last time, "Beat it, or I'll hit you with my Q-tip." So there it is. Lawyers and their acronyms. Oh. So how are trusts taxed? Revocable trusts are taxed to you, the grantor of the trust, because you fill all the roles, right? And mostly because it follows your social security number. So that's kind of the key. If the trust uses your social security number as the ID number, then it's going to get picked up on your personal income tax. Revocable trusts are included in your estate for estate tax purposes. So because you have the ability to control the trust, to take back what you put in it, then therefore at the time you die, you can't then claim, well, hey, I shouldn't be taxed on it because it was in a trust. No, you had control over it, so it's going to be taxed. But because it's included in your estate and taxed, you get this benefit called a step up in cost basis. So cost basis is essentially what you paid for an asset originally. If you take a house, for example, and let's say you bought your home for $200,000 and now it's worth $500,000. And you sell your home, there's a $300,000 capital gain, and potentially you have to pay tax on that. There are rules for primary residences where you can get exclusions, but just for the sake of our example, does that then mean if you died and that home passes on to your kids and they want to sell it, are they going to have to pay tax on a $300,000 gain? Well, the answer would be no if it was in a revocable trust, because it's included in your estate and you'd retain eligibility for that step up in basis. So the $200,000 basis number would get bumped up to what the property was worth on the date of death. And if it was worth $500,000, then that means the new basis is $500,000. So when they sell the property, fair market value is 500, basis is 500, so 500 minus 500 is 0. There is no capital gain. It's a little bit different with an irrevocable trust. Irrevocable trusts may or may not be included in your estate, depending on how you structure it. But if you structure it so that there is no estate tax on that when you die, then you are giving up the right to get the step up in basis. And that was clarified by the IRS last year. So it's kind of a trade-off with that. If you want to save the estate tax, then you may be giving up the benefit of a step up in basis. So you have to look at the assets in the trust and say, geez, am I going to have a high capital gains tax, or am I going to have a higher estate tax? And you kind of play it as a balancing act. Which one do I want to save more on? Irrevocable trusts can be taxed to you, or they could be taxed as a separate entity. So you can actually do those either way. You can use your social security number, or you could get a separate tax ID number. And there are benefits and disadvantages to doing both. So is there a winner? Is there a winner between revocable and irrevocable trusts? Well, revocable trusts check the box for easier estate settlement, avoid probate, save estate tax, and they have inheritance protection. But they don't check the boxes for saving income tax, long-term care protection, liability protection, or divorce or creditor protection. So the irrevocable checks all the boxes. So I guess, does that mean that the irrevocable trust is the winner? And I would say it depends. I had to sneak that in. I had to sneak in the typical lawyer answer of it depends before we end today, because you're not getting an answer out of me. It depends. Yeah, of course, it depends on your situation. It depends on which of these issues are important to you. You may have no interest at all in protecting against the nursing home, or you may have no interest in protecting the inheritance for your family, but you say probate is so important. So you kind of talk through that with that's what we do with our clients. We just talk through these issues, figure out what's driving you and your family, and that kind of helps us take you in the right direction to the appropriate trust for you. So that was a lot to throw at you. Yeah, a little comic here. So you have if you build your house out of an irrevocable trust, like the little pigs did, then I guess you're good. The big bad wolf of Medicaid can't blow it down, or estate tax or other issues. They can't get at it. So that's the idea. So we'll take some questions in a moment. Just before we do, wanted to let you know of 2 upcoming talks. I alluded to one earlier, Legacy and Libations. So that would be planning for estates under $4 million. And our associate attorney, Deb Hedges, will be the speaker that night. She has a very great event planned for everyone. So that's March 27th. And then our state administration attorney, Mackenzie Hager, has a really good program set up called How to Avoid Problems, Settling Your Parents' Estate. So I'm sure will have a lot of good stories to tell there. She settles a lot of estates. And for everyone that's attended today, we just want to make you aware that we're going to offer 2 complimentary meetings. One would be a welcome call with our senior paralegal, Courtney O'Riordan. And then the second would be a free initial consult with one of our attorneys, and that's a $950 value. So if you scan the QR code, head to that address on the website, or call the office. Any way you get in touch with us, just reference the seminar that you attended tonight. Which trust do you trust? And you'll be eligible for that. So, yeah, I think that's it. We can take some questions now. Any questions here?
My father passed away back up to say, right, 95, and then a couple years later, my mother we went to a lawyer, or she actually got a lawyer, and we put her main asset was the house, okay? The house was put into irrevocable trust, and for 2 reasons. One was, the big reason was, Medicare, and my mother made it through the 5 years, and it worked out well because she ended up having health issues and was in nursing home for a long time, so it worked it in. But also the cost basis, when my mother did pass away, we were able to sell the house, and we were able to get the increased cost basis. When you mentioned it was sell the house, we were talking, my wife and I put our house, you're talking about, if we sold the house, you get the step up basis, or you talk about if we pass away, my kid, in Irrevocable, I was told that you do get that step up in cost basis. That's why I'm a little confused.
Okay, yep, that's a good question. So the question here was, are there any circumstances in which you could retain that step up in basis if the house is in an irrevocable trust? And the specific type of trust that was referenced is a Medicaid type of irrevocable trust. So the answer is that you would lose the step up in basis at death with an irrevocable trust if that trust is set up to avoid estate tax. And so in other words, if you say for tax purposes, I am cutting ties with this property, so when I die, there is no estate tax on it. If that's the way you're setting up the trust, then you lose the step up in basis. With the Medicaid, irrevocable Medicaid trusts, they are often not set up that way. So they are often included in your estate for estate tax purposes when you die. So they're designed primarily for the purpose of qualifying for Medicaid. They're not really designed to save estate taxes. And therefore, you do get the step up in basis, because when you die, that value, say you put the house in and it's $1 million house, and if all your other assets were, let's say $2 million, so you have a $3 million estate, you put the house in an irrevocable trust, but it was a Medicaid trust. So that $1 million of value is still included in the total tax calculation. So you'd have $3 million that would be subject to tax. You wouldn't subtract that 1 million out of that because of the type of trust that you're using. So typically those trusts do get a step up in basis because they're not focused on estate tax, they're focused on Medicaid protection. Yeah, it all depends on the kind of powers you put in there and rights that you retain. So most of the time, I mean, I have a few where we tried to combine both estate tax and Medicaid. Most of the time, we're not doing that. You say, no, we want you to get the step up in basis. and we want you to have the nursing home protection. So.
I do have another question with the other people, I'll let them go first.
I
Okay.
don't see any in our chat, so go.
Okay, yep, go for
All
it.
right, now. We're considering doing an irrevocable trust, all right, or, or a living trust, not sure. Besides the house, that's our, one of our main assets, my other main asset, and this is probably 90%, and I'm just speaking freely here, is my retirement, which is in my, I have a separate managed IRA when I managed. Right now, my wife is the beneficiary of that, and my two daughters are the sub-beneficiaries. I was told I don't have to do anything with that will pass to them. Or if I pass away, that will pass to my wife, and then from there, when my wife passes away, that would pass to them without probate.
Mhm.
Is that, so would I have to put that in either a living trust or irrevocable trust, or is that not the case?
Okay, yep, another good question about retirement accounts. And do we have to name a trust as a beneficiary on a retirement account if you've already named a spouse and children as beneficiaries? I mean, isn't that good enough to avoid probate? And the answer is yes. The way you have that set up, spouse as a primary beneficiary, children as the backup, that would avoid probate. Absolutely, because that they would have the right by law to take that account. They wouldn't have to go to court to get access to it. The benefit to using a trust as a beneficiary, and typically when we do it, the trust would replace the kids, not the spouse. So you'd still have the spouse as the primary beneficiary, but the trust becomes the backup beneficiary in place of the kids. And the benefit there would be if you wanted to protect the inheritance for the kids. So if you want to protect the money they get from the killer Ds, divorce, debts, disability, disputes, and all that, then you would want the retirement money to flow through the trust to the kids rather than to the kids directly. So that would be one benefit. If you wanted to save estate tax, you may want some of the retirement money to flow through your trust to save some estate tax. So
can I ask you a question next?
Yeah.
So by what you just mentioned, so I have my daughter's married and I have one grandchild, okay? Her allocation of my retirement funds, all right, when my wife, we both die, right, she gets that. But then if she gets divorced, that money's subject to my son-in-law, and it's nothing against my son-in-law, then could possibly get some of that. Whereas if it was in the trust, it would all go to my daughter. Is that that's the protection issue?
that's the protection issue, exactly. Anything passing to your daughter in trust, if it's done the right way, could have protection if there was a subsequent divorce. Yeah.
And then the other benefit of living trust is if something happened to and again, we set this up now, God forbid, something happens to my daughter now, I'd want to make my grandson get that benefit, not my son-in-law. Again, nothing against my son-in-law, but I want it
Yes.
all to go to my grandson. So is that why I'd want to do a living trust?
Ye-
Or can I do an irrevocable trust? Because my other issue is the whole thing, what you said about the Medicare, that Medicaid, it worked well for my mother's situation. That worked very well, or that, on that. So can that be done in either one of those trusts where if something happened to my daughter she passed away before we did, all right? How do I make sure that my grandson gets her share rather than my son-in-law?
Right. Yeah. So yeah, the way that you make sure that your grandson receive your daughter's share if something happened to her is what we'd call bloodline planning, right? So you would be very specific that in whichever trust you chose, whether it's revocable or irrevocable, it can be done in either one, that if the beneficiary has predeceases you, or if she died after the fact, that her share would then pass to her descendants. It would not pass to her spouse. So you'd be very clear that there's this bloodline direction of the assets, the way they pass. And as long as the spouse is not named, and then as long as you structure the trust in a way that spouse wouldn't be able to kind of get at it if there was a problem, then you could be assured it would pass to the grandkids.
So that's one reason to do a trust, yeah, I'm gonna say one trust or the other is to have that scenario. Whereas if I just leave them as beneficiaries right now, the way it's set up, you know, they're subject to one of the Ds that.
Exactly, exactly. Yep, yep. Yep, you got it. Yep.
Can I, you know, again, in the other, maybe this is not a question, you can tell me that, no, you have to wait to see. So right now, I know that if, let's just say I pass away, my wife passed away, my daughters get my retirement, all right? They then, I know I'm paying taxes on that when I start taking distributions. I've heard they have up to 10, you could structure, I would structure that, or would they do it so they have to take it over? I don't want to see them get hit with a huge income tax all in 1 year. Can they take, I've heard you could take that over 10 years?
Yeah, you're actually forced to take a beneficiary, a non-spouse beneficiary who inherits a qualified retirement account would be required to take distributions over a 10-year period. That's the general rule. There's some exceptions to that, but yeah, previously it was that the beneficiary could take that over their lifetime. So they could more or less treat an IRA, for example, that they inherited from their parents, you treat it as their own IRA.
Gotcha.
And like just
Now
stretch it out based on how old they are and their life expectancy. And it could have went on for a very long time, but now, yeah, the law change in 2020 under the Secure Act said that it's now a 10-year payout. So at the end of 10 years, the IRA has to be depleted and all the money net of taxes has to now be in the hands of the beneficiary. So that would be another, yeah, absolutely another reason why you'd want a retirement account to pay to the trust, because you know it's not going to stay as a retirement account for more than 10 years. At the end of 10 years, it's not going to be a retirement account anymore. Now it's just going to be, you know, cash that's got distributed out. And so you'd want that to still be in trust and protected for the child. Oh. So
Mark, we have a question. Do you see it? Yeah.
Yep. Yep. So, so Hillary is asking, hi, Hillary, how are you? Hillary's asking if the grantor of a revocable trust passes away before certain assets change ownership to the trust, what will happen? Will the estate then require probate? So that's a good question. That if you more or less the concept is if you've done a trust, right? You've gone through all the proper steps of creating a trust. You decided you wanted revocable in this case, and you pass away though before changing ownership or beneficiaries to the trust, then the answer is yes. You may very well end up with a probate. Because it goes back to that example of the bank account I was using earlier, that even if you had a trust in place at that time, but you never told the bank about it, you know, or the bank didn't have the trust registered on that account, you can't just walk in after the fact, you know, after the grantor dies and say, well, they did have a trust. They meant to put the account in, but they just didn't get around to it. The bank's gonna say, sorry, you know, that needed to happen before death. So, so yeah, it does. That's very important. We call that trust funding. So you kind of run down the balance sheet, looking at every single type of account and making sure that each one is put into the trust or has the trust as the beneficiary. If that doesn't happen, there is a fail-safe built in most of the time. So when we do trust planning, we'd still have you write a will, and it's called a pour-over will. So the will would say, if any of my assets didn't make it into my trust while I was alive, then I want my executor to put them into my trust at death. So that bank account example, you'd have to go through probate in order to get access to it. But once the executor has access to the bank funds, then they have to read the will, and the will would say, oh, I'm supposed to put this into the trust. So they would just take the money out of that account and put it into the trust account or create a trust account. So it would end up in the trust eventually, but in that scenario, you had to go through probate to get it there. We'd prefer that it get into the trust ahead of time. It's a good question.
Thank you.
Let's see any other questions in the chat. You guys have
Well,
other questions?
So I've heard the other thing, of course, reading online about it, irrevocable trusts that they say are more expensive. I guess that's how much more expensive, or is that a subject for another? I mean, when you say, you know, there's a will, there's a living trust, irrevocable trust. Is it, you know, exorbitantly more expensive to do? I don't really remember when my mother's went in. I didn't think it was that much money when it happened.
Mm.
Because my mother would have complained if it was at the time. All right,
Yeah.
so I mean, you know, how much more expensive is it, you know, like you said, it checks off all the boxes, okay?
Mhm.
You know, and you said for the most part, it's probably the winner, but there are exceptions to that. But what are we talking about? How much more expensive would that be? Is it to do an irrevocable trust?
Yeah, it's not any more expensive than doing a revocable trust. So yeah, I guess it depends on the type of irrevocable, but I'm fairly certain you're referring to an irrevocable done for Medicaid planning purposes. So if it's that kind of an irrevocable, yeah, for our purposes, the cost it's the same, unless you're doing a very simple plan, which oftentimes you see younger families doing like a simple revocable just to kind of get their feet wet and get something going. That could be a little less expensive, but if you're comparing a mature, full-blown revocable against an irrevocable for Medicaid, the cost is the same. And yeah, it's when you get into irrevocable trusts to save estate taxes and you're doing gifting and you're thinking about, you know, higher net worth estates, they're doing more complex techniques, then the cost can change. Any questions? Any others? Yeah.
If an irrevocable trust is created and just say, for example, like a house is the primary asset that's put into it for Medicaid purposes, can you add assets to it afterward?
Yeah, so the question was, if you put a house in an irrevocable trust for Medicaid planning purposes, can you add assets afterwards? And the answer is yes. You can always add to that trust. At the time you add, you're going to start a new 5-year clock running, but only for that addition.
Oh,
Yeah, you won't interrupt the 5-year clock on the previous transfer of the home in this example. So every time you move something in, it has its own 5-year clock. So adding to an irrevocable is yeah, never really the issue. It's taking it out, taking it back. Yeah, that becomes tricky. All right, well, I think we've exhausted our questions and kept you all long enough. So thank you for attending. And hopefully you took something away from this, and please just feel free to reach out. We're happy to help in any way we can. So, and look forward to seeing you at some of the future seminars. Thanks.